Hi, I hope you had a good, restful holiday. Today we're going to talk a little bit about the oral argument assignment essay. It's technically due December 31st, but that's kind of a jerk move on my part. So if you can get it done, sometime by like maybe January 3rd or 4th, that would be great. I just want you to keep a pace in the class and not save everything until the last possible minute. So I want to tell you a little bit about the assignment. The what you're going to be doing is listening to an oral argument delivered before the United States Supreme Court and analyzing it and then writing about it. Why do I assign this? The purpose of this assignment, it's twofold. First, it is part of the judicial process, especially the appellate part of the judicial process. Unlike a trial court where, as you know, trial courts are finders of fact. Their job is to say, okay, what happened? So you have a law, don't murder people, and then Bob's alleged to have murdered John. And so at the trial level, you're asking, did Bob murder John? At the appellate level, you're no longer looking into that. You take as given the facts as established by the trial court, judge, and jury. At the appellate level, you're asking questions of law. For example, did the court correctly define murder? Was the jury given instructions in a way that would prejudice the outcome? Did the police honor the requirements of the Constitution when making the arrest? And so those are all questions of law. So they operate differently, too. They have more than one judge, usually panels of anywhere from 3 to, at the Supreme Court level, 9 judges. And it's the lawyers that are arguing on either side, trying to address the concerns and questions that the judges have. At the Supreme Court, oral arguments are scheduled for an hour, 30 minutes each side, with some exceptions. Sometimes they have a little bit longer than that. But sometimes it looks like it's a series of dialogues between the attorneys and the justices, but really it's more of the justices talking to themselves through the intermediary of these attorneys, because they're trying to get things out there. They're trying to, they've read briefs for both sides, and they're familiar with those arguments, but there are certain aspects that neither side might cover. They also are, especially at the Supreme Court level, going to explore with the attorneys the implications of answering the question one way versus another. It's this, to see it in person, it is really kind of an awesome experience. It's this really interesting juxtaposition of something very formal with a lot of power and circumstance. They're the only part of the government that wear a costume of sorts, because at the Supreme Court building, the courtroom, they come out from behind these velvet curtains all at the same time, and the marshal of the court introduces them with this thing that they say, oyez, 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 all those who have business before the court now draw nigh, the court is now in session, and so you have all this very, very much formality and pomp and circumstance, and yet, once the discussion starts, it becomes kind of intimate and informal, and not unlike the discussion in a philosophy classroom, where you're exploring hypotheticals and seeing the extent of how far you can push these examples. And so part of so my first purpose in the assignment is just to get you familiar with this part of the judicial process. But the other thing it will do for you, whether it's for this course or other courses dealing with law or anything really, is that it polishes, it hones your skills in the ability to take in complex information and complex arguments, to analyze them, and then to summarize and present a coherent discussion of that information. And that's, if you can do that well with this assignment, this is the kind of skill that you could take to any job anywhere, and it would be highly valued if you can do this well. So this is great practice, not just for this class, but really just for professional life in general. If you want to have a job in which you're taking in complex information, assimilating it, synthesizing it, analyzing it, and then communicating your findings about that information. So let's take a look at the actual assignment itself and what you need to do. Okay, here we are on the Moodle page. Go ahead and click on Oral Assignment Guidelines, and here you're going to see the guidelines. Now, don't get freaked out when you see that it's 12 pages, because actually just this first page are the guidelines. The remaining 11 pages are a couple of short background articles. One of them is just 1 page, and then another one that's about a little over 10 pages that give you a little bit of background about why we have oral arguments and the purposes. This second author talks about the purposes of oral arguments and how that comes out in the types of questions and answers given at oral argument. Then he talks about the questions, and he has categories of questions that the justices asks, and towards the end he even categorizes common mistakes by attorneys. So what I think would be a good, you're going to be writing based on these questions and you're listening to the oral argument. Your essay is going to be 4 to 7 pages, double spaced, and here's how I would suggest that you proceed. First, I would read the background essays first and see what's going on there. Second, I would read the actual requirements. You're going to start out with an introduction where you kind of tell what the background of the case is. Then you're going to talk about a little bit on each side about, give the gist of the arguments. Now, you're not going to analyze every question by each justice and every answer. There's going to be some patterns that emerge. So based on what you heard, identify that, go to the part of the article that was signed and find maybe 2 purposes of the argument that you heard expressed. Identify 2 categories of questions. Identify 1 or 2 types of mistakes made by the attorneys. Again, this is just to give me examples of it. It's not a line-by-line analysis. And then I want you to tell me which side made the better arguments, and I'd like you to focus on not on which side you would have hoped to have won, but which side actually made the better arguments, even if that wasn't the side that you wanted. Tell me which side actually won, and then I'd like you to tell me, are oral arguments a necessary part of the process? Some people, notably one of the current justices, Clarence Thomas, does not think that they're necessary. He would say, I've read the copious briefs and the documents that are submitted by both sides. I've kind of made up my mind. He also makes the point that oftentimes there's so much going on that the lawyers can't get a word in edgewise, for the justices keep interrupting them. On the other hand, other justices feel they're absolutely essential. Recently retired Justice Anthony Kennedy, when asked whether they're necessary, he said, of course they're necessary. They have to be necessary. That's the power and the passion and the poetry of the law, that a rhetorical argument becomes connected with a real person through the attorneys and what they're telling the justices. So after you've then read through these, then go ahead and click on this link, and this link will take you to the website and to the exact case that we're going to be using. Okay, so the link on the guidelines will take you not only to the OIA.org webpage, but it will take you right to the case that's being argued which is RG and JR Harris Funeral Homes Incorporated versus Equal Employment Opportunity Commission. You can read about the background of the case, the specific question that's being asked, and basically it's just asking, does the Title VII of the Civil Rights Act of 1964 says that in employment there won't be discrimination because of race or because of sex. And the question is, at the time that was written, they were just saying you won't discriminate against hiring women in the workforce. But this case is saying, but does that phrase because of sex include transgender people? There was a case that was heard at the same time and handed down on the same day, asking if sexual orientation is included in that phrase. This one is asking, is transgender included in the phrase because of sex? So to listen to the argument, you click here and it pulls up both a transcript and the audio.
We'll hear argument next in case 18-1.
And you can see that you can follow along with that as the argument goes along. You'll see here the arguments are an hour, and that is pretty much it. So sorry for the length of this video, but I just wanted to try to explain it to you the way I would have if we were in the classroom together. Don't hesitate to send me emails with questions, and I can either email you back or we can set up a time to meet and have a Zoom meeting. Okay, talk to you soon.